Hi, everyone. Thank you for joining today's webinar presentation, Taking Ownership of Your Patent Portfolio. I am Gail Martin, Associate Marketing Manager at ReedTech, and I want to cover a couple of things before we get started. Please feel free to submit questions during the conference by using the chat or Q&A feature. We will be sending you a copy of the slides and a link to the recording from today's presentation. Now I'd like to introduce today's presenters. Eric Zazer. Eric Zazer is Patent Counsel at Google and is responsible for developing and implementing patent strategy, including portfolio management, analysis, and evaluating patent opportunities. He advises and counsels client relationship representatives, including executives, on patent strategy and on IP issues in commercial and product contexts. Chris Holt. Chris is Vice President of Patent Analytics and co-creator of LexisNexis Patent Advisor. He has over 15 years of experience as a patent attorney specializing in U.S. and foreign patents in the electrical and mechanical fields, as well as computer hardware and software inventions. He is co-host of the LexisNexis IP Solutions podcast, Better Patents Now. Thank you again, everyone, for attending today's presentation, and with that, I will turn it over to you, Chris.
Excellent. Thank you very much. Welcome to the webinar, Eric. I'm excited to have some good discussion with you today about patent prosecution, my favorite topic.
Yeah. Hi. Thanks. Yeah. Thanks, Chris. Thanks for having me. Yeah. This will be a fun one. I can talk till the end of the day on patent prosecution, but I know we only have an hour, so I'm excited though.
Awesome. Why don't we take maybe just a minute here, and each of us sort of explain kind of what our path was from law school to where we're at now, so people will sort of know our backgrounds before we jump into the good stuff.
Yeah, sure. Sounds good.
Would you like to go first?
Excellent. Oh, sure. Yeah. All right. So, my path to here starts in the professional context. From I was getting my bachelor's in electrical engineering, and there was a co-op opportunity with a patent law firm. And I had no idea what patent law was, and the only thing I knew about being a lawyer was I didn't want to do it because I didn't want to go to school more. Specifically, I was worried about spending a whole lot of time researching and reading things, which I thought I could never do. Little did I know, but I did this co-op at a small law firm in South Carolina called Doherty & Manning, and it ended up being a really great experience. I actually was really interested in learning more about patent law, so I went to law school, University of South Carolina, and then I actually went to work for Doherty after law school, and had a wide variety of small clients and larger clients, and it was mostly patent, a little bit of copyright, trademarks, and trade secret. And the patent work there was a little bit of litigation, but it was mostly prosecution. I had a friend down in Atlanta who convinced me to join a larger law firm. It was Kilpatrick Stockton at the time. Now it's Kilpatrick Townsend, and had a really good time doing some more patent prosecution, specifically some technology clients. And I ended up just getting this opportunity to come to Google. It was just over six and a half years ago now. And
time flies.
Yeah, and it's funny because I grew up in a small town. And I was like, I'll never go to the city, and I went to Atlanta, which is like as big as the city gets. And then when I was in Atlanta, I was like, well, we would never move somewhere crazy like California. And I moved here, and it's crazy, but I love it. And so I've done a few different things here at Google. Sorry.
No, go ahead. I'm sorry.
Oh no, I was. I always like to make. So I'm working at Google, but I always give my disclaimer at this point that these are my personal opinions. They're not official, statements on behalf of Google or anything like that. And just for the heck of it too, nothing I'm about to say is legal advice. So think for yourselves and brush your teeth. All the usual disclaimers on that point.
Perfectly spoken as a lawyer. I'll give you sort of the speed trip to where I got where I'm at now. So, and it's funny, I also grew up in a smaller town. For me, it was in western Kansas, I went to a career event in high school, and I asked the local attorney whether lawyers make lots of money, and he said, no, but patent lawyers make lots of money. So I decided when I was like 17 that I was going to become a patent lawyer because allegedly they make lots of money. And I didn't actually know what a patent was for probably another 5 years after that. But you know, fast forward, I ended up getting a physics degree, going to law school specifically to become a patent attorney, was a patent attorney at a Minneapolis firm in Minneapolis, Minnesota for 12 years, did basically nothing but prosecution. About halfway through my career, became fascinated with patent office analytics and really ended up starting my own company, which has now become Patent Advisor when we were acquired by LexisNexis a few years ago. So as we go into this topic today, now let's kick this off a little bit. So we're going to be talking about patent prosecution, how have things changed, and you know, we have, both of us were in private practice, so we have this perspective of what it was like to be an attorney out there in the trenches. Now that you have sort of this corporate perspective and this management perspective, and I have an analytics perspective. And one of the things I would like to explore, and we're looking at our first slide here now where we're talking about, you know, then and now, how have things changed? You know, from my perspective, one of the really interesting things is patent office analytics is a thing now, right? For a long time, you didn't know the different areas of the patent office and how efficient or not efficient they might be. That was just not information that you took into consideration. But now we have the opportunity to know, you know, even down to a specific examiner, kind of what their tendencies and preferences are in terms of prosecution. You know, is that something that you see infiltrating into patent prosecution management these days?
Oh, yeah, for sure. And it's funny because I think it's infiltrating into everywhere. I don't know if I just saw this morning on my way in to work. The USPTO has just released a whole set of projections and analytics. There's like it's a really good white paper. I guess it came out on the 30th. USPTO Patent Prosecution Research Data Unlocking Office Action Traits. And, you know, I think it's really, really cool that not only is analytics, you know, getting into the world of management, but the PTO is also paying attention and has started. It looks like a pretty impressive analytics project and data set.
Yeah, you know, it's kind of like one way to look at it is that in our heads for a long time in the prosecution world, we sort of assumed that every examiner was the same, you know, that they had a similar allowance rate, a similar amount of time to allowance, a similar preferred number of office actions. But what we know now that there's a lot of variability, you know, not just based on technology areas, but even based on, you know, within a group based on, you know, where the examiner is in their career. And so, you know, if you are aware of these things, you know, there's two ways to look at it. Number one is that's certainly going to inform your prosecution decisions. But now to think about that from a portfolio management perspective, I'm wondering how data sort of comes into play in that sort of big picture environment.
Oh yeah, I mean, I think, you know, I think in the old days, I think I'm old enough to refer to the old days now. You know, there's this kind of unstated assumption that, you know, that every single thing that you could possibly patent was going to be worth it. And, you know, the way it plays out is some things are extremely valuable and other things are not. So, you know, like the bullet point says, there's no longer unlimited patent budgets. But then, you know, that means you're giving something up, so you have to find some way to prioritize, and you have to understand, you know, where the value is, and then also, you know, what's the way that makes sense for you to actually get something of value. it's like you said, you know, the different folks at the patent office. And I would actually, you know, and the same idea goes out across the whole chain from the point of, you know, invention, outside counsel, patent examiner. Everyone has goals, and they have different ways they're trying to achieve their goals. And so, you know, having the analytics there helps you understand like how to work with people. It's, you know, I mean, on the more like soft side, you know, like there's the different like the different personality types and tests and that sort of analysis. You understand that, you know, some people are visual thinkers, some people are more about words. And if you understand the best way to communicate something with someone, you can have like a much better outcome. And I think the same thing is true with other analytics, is like you understand how someone works and what is working for them to help them achieve their goals. I think everything gets done a little better, and you're also achieving your own goals better. Like if you understand, like, I'm doing something and it's not working, then do something different, right? You know?
Yeah, I agree completely. I think that in the beginning, you know, I've been working in this sort of patent office analytics area since 2005, 2006, because I was incorporating it into my own practice. But as it became more public, I think the first perception of this kind of analytics is that, hey, the real purpose of this analytics is to go out and find really bad examiners and call them out, right? But in reality, I think it's exactly what you said, is that when you know that if you can align expectations with the examiner. So for example, suppose your examiner averages 3 office actions per grant, right? I don't really have a problem with that if that's the way that they like to go about doing their business, right? Their work. But if I know that ahead of time, it allows me to sort of adjust my prosecution style to the way that they usually like to do it, right? And
oh yeah, exactly.
On the other side of on the other side of that coin, if the examiner averages 1 office action per grant, and I'm at number 3, I know it's time to pick up the phone, right? We're getting off track here, right? And that ultimately is beneficial for everyone.
Yeah, it makes me think back to when I was, you know, I have this note of, you know, I guess it's actually true with all aspects of my career. It's like all the goofy stuff I did when I was a young associate. I guess I'll limit the stories to ones outside the statute of limitations, just for but you know, like I just remember, you know, sometimes especially fresh out of law school, you get like this office action, and you'd be like, oh, this examiner, oh my gosh, she's rejected all my stuff, and you know, the guy's just trying to block everything. And you know, in reality, I know some of those times it was the patent examiner who knew like 1,000 times more than I did about the art and the space, because you know they've been doing it longer, and that's their area of expertise. And you know, I don't know how it plays out in the analytics, but you know, that's probably more of a one office action examiner if you call them up and they tell you exactly what they're seeing. And then, you know, then sometimes you would get someone who's like an examiner that was, you have a very nice, like almost law school like, you know, memorandum like office action. And it's like, you know, here's someone that wants to write it out and, you know, be very procedural. You know, I think sometimes some people actually are going to law school. I know people who are, you know, attorneys that went to law school while they were at the patent office, right? And, you know, to the extent that you work with people the way they want to work with, like, I think it makes everything so much better for everybody. Because I mean, you know, they have a goal. They're trying to do a job. They're trying to do a good job getting a good patent out, or getting a good patent examiner, getting a quality patent or a good quality office action if there's not a patent that's supposed to happen there.
Right, which is, you know, and to me, if you are an attorney that is working with the examiner, to have that alignment and expectations, I think, is critical. Then when I think of, and I'm not a portfolio manager, but I felt like I was about to say I'm not a portfolio manager, but I play one on TV. But what I really mean is that I'm not a portfolio manager, but I work with portfolio managers all the time. And what I sort of see the way that this category of analytics is infiltrating, and you tell me if this resonates with you, is that, early in my career, people looked at their portfolio of pending applications, and, you made a comment earlier that sort of goes to this, that, in the beginning, every asset in your portfolio was important, right? And then the second trend that I saw was as portfolio size grew, the next trend was to sort of start to evaluate your pending applications based on business value so that you can prune things that, are no longer important in terms of product mission or, unlikely to produce licensing revenue. So to sort of do this business value analysis. But isn't it interesting now that you can also consider, when are we likely to get a patent? How much is it likely to cost? And sort of those predictive elements so that you can balance that against the business value. Is that sort of, does that resonate with you?
Yeah, I think that's true. So one of the things that comes up, and this is both in the in-house experience and even in the law firm experience, is people are going to all this trouble to get to try and get a patent, and they want to know when can I get a patent? And the answer was always the classic lawyer answer, which is both accurate and not exactly helpful. It's like, it depends.
Yeah.
And I know when I started, like, the best competent advice you could give was like, you could say what the average pendency time was, and then, especially in that time, in that era, it was like the average pendency was whatever, plus it seems like it's going up.
Yeah.
And now, now they're, with the analytics, and just better data. I think another part of this too is there's more structured data everywhere, and you can give at least a better range. You can be like, hey, not only is average pendency, I think the last thing I saw is that it's going down across the board. When you can break it down by art unit, once you have the patent file, you can be like, this particular art unit takes a little longer, or this one's a little faster. And then, of course, there's all of the different programs that are available too, that the accelerated examination, patent prosecution highway. To be able to just have a meaningful conversation about how, hey, you can expect an asset here, if you get one, in this kind of range, with a much smaller disclaimer. That's much. I think it's a lot more valuable. Again, either in terms of the advice provided by an outside attorney, or even on an in-house kind of situation. Hey, in either event, it's like, hey, they're doing this thing. It costs a lot of money, and when are we going to see some results? And you can say something better than I don't know, maybe probably less than 6 years from now. You know what I mean?
Yeah, exactly. Yeah, and then, I think that it will just get more sophisticated. I think companies will say, okay, look, in this technology area, we filed 40 applications, and we had, 20 of them seat with reasonable path examiners, and, this amount with longer range, because it's also an issue of quality, right? Some examiners are more likely to give you narrower or broader or higher quality or lower quality, and I think it's going to become more sophisticated. Before I switch to the next slide and introduce our next topic for discussion, I like the point you made. I mean, it's really more than just patent law, right? Because if you were like me and you drove a tractor in the 1990s, and if my wife were on this webinar, she'd be writing in right now saying he didn't drive a tractor very often, but so maybe that's a bad example. But, a person that drove a tractor in the 1990s, your job was a heck of a lot different then than it is right now, right? Because you have a lot of data about, where are the wet spots and how much seed do you plant? Everybody's jobs are changing. Why shouldn't our jobs change too, right?
Yeah, and I mean,
so go ahead.
Oh, I was just going to say, so one thing, I had a very nice kind of nerdy engineer background story, and so I never spent a lot of time like going to the gym or anything like that. And then now I do now, because I'm trying to continue to be able to pick up my kids, and even there's analytics like really, you can track your progress over time, and you can tell like, hey, am I getting better at this? Am I getting better on the exercise bike? Am I doing better lifts, or am I plateauing? And again, it's that whole thing. It's like, well, is what I'm doing getting me towards a goal? And should I try doing something different? And it's really, I don't know. It's scary in the sense of it. You have to confront some truth, but it's also helpful because you actually are making some progress, or you decide you don't want to make progress. It's like, hey, I don't want to go to the gym as much as I need to be able to get to this goal. I want to sleep in. That was what I chose.
Yeah, being able to measure things changes the game, for better or for worse. Change is not easy, and having everything in your life infiltrated by micromanagement and data-driven decisions is not comfortable, but it's inevitable, and it's certainly inevitable in our practice area, I think. If the data's available, why wouldn't you look at it, right?
Yeah, and I like the bullet point on the then and now slide here. That you're balancing intuition and insights from the analytics, right? You don't, because I think just going complete data without any actual thought, that's as bad as not having data at all, right?
Sure.
I think in the in the technical sense that would be called overfitting, right? If you had a whole bunch of data points and you did something you automated something to exactly follow all the data points, it has left no room for error or new situations. So I think that's something that people are even now are already getting, is that like the data can be helpful, but it's like anything. It's not a complete linear situation.
Yeah, and I think a good example of that is like if you're choosing whether to file an RCE, right? What got me started in this category of analytics in the first place was, at the time, one of our main clients was a software company, and when we were filing an RCE, sometimes we heard back from the examiner in a month, and sometimes it was 3 years, right? And so I had the idea that said, why not? If you could download enough file histories, you could calculate what the wait time is lately. And so if you're making the decision about whether to file an RCE, wouldn't you want to know how long it's going to take to hear back from the examiner? Ultimately, it's still your decision, right? But you can now have that piece of information to weigh into the calculation of that decision that you didn't have before. Instead of getting stuck on this slide, I'm going to push us one step forward here. We're going to talk about big picture, high-level strategy, which is sort of in your wheelhouse. So I'll let you sort of kick this off and give us your thoughts.
It's funny, yeah. My note for that is different actions become clear to meet your goals once your goals are defined, and it goes right into that RCE example. It's like, if you had an RCE wait time of 3 years, well, maybe that's okay, depending on what your goal for that that part of your portfolio is. If you need something right away, products, short life cycle, or you're trying to, maybe you have maybe some sort of defensive need for a patent there. Yeah, you're not going to want to.
You're in the pharmaceuticals business. I understand that, and like in pharmaceuticals, that sometimes they want to delay to sort of time with FDA approval and things like that.
Oh yeah, I was going to say I don't practice in the area, but I'm like, if you have a portfolio full of molecules and you don't know which ones are going to be the hits, 3 years RCE, that's probably okay. But then if something is on the market now, or that's a different situation, I would bet.
Sure.
But to get to this idea, getting back to the ownership. And a disappointment to anyone that was hoping for us to talk for an hour about assignment practice. It's metaphorical ownership, but it's, in my view, it's when I say ownership of the patent strategy, it means that, the buck stops here. Your strategy is supposed to solve some problems, and so you're the owner of those, and you know, the first question that springs to my mind when I throw that out there is like, well, what if I don't actually set the strategy, right? I'm outside counsel, or I'm team member number 5 in a team of a zillion people, or something like that. That's not a free pass. You know, you still own your piece, and you still have to understand it, right? You know, if you're in house, talk to the business people or your manager, or you talk to the senior patent counsel or whoever. If you're the new associate, you talk to the managing partner so you understand the strategy. And then, you know, even if you're not like the nominal owner, you're still executing on it in some way, and so you have to influence it. And doing nothing, you know, blindly trying to follow, that actually is also influencing it, right? Like if you're just not giving any feedback on the strategy and executing on it, well, you're kind of endorsing it. So, you know, one way or the other, you're part of this whole thing, right?
Yeah, you know, I've spent a lot of time outside of the U.S., and so I'm going to a lot of corporations that are filing applications in the U.S., and you see this big shift. I mean, I've seen it in my time of visiting companies, is that, you know, a lot of foreign companies, the initial thing used to be, I have my U.S. counsel to take care of this for me, right? A real hands-off kind of approach. But those days have really, really changed, right? And
oh, yeah.
Because if you, the corporation, are not really getting involved in, because just like you said with the RCE decision, you know, the outside counsel more often than not, especially when it's the first final action, is going to sort of default to filing an RCE, right? And if you, the company, are not sort of deciding how to influence that decision, you know, we even see a lot of companies that are just sort of, they have a routine that, look, we always file an RCE, right? And that seems kind of dangerous too.
Yeah, and I mean, and that's, you know, I guess, I think the danger is if it's not thoughtful, right? If it's not, I'm trying to think of a better word than thoughtful, but, you know, it's a reasoned, considered decision. You know, if the approach is, it comes down to, like, you know, figuring out goals for your patent portfolio. Like, you know, are you doing kind of the classic patent use case of defining something that you want to protect with some sort of exclusivity, like the drug example, or, you know, industrial designs or something like that, or, you know, I think another example use case is the ROI, like, you know, the startup or the R&D, like, you know, they put a bunch of money into something and you're trying to capture some value there. You know, I think maybe on the university side, sometimes that's also maybe a strategy you see there. It's like, hey, we're doing a lot of interesting new stuff. But, you know, is there some way to use patents here to capture that value? And then, you know, another contrasting strategy would be the defensive side. Like, you know, there's some companies, I call it Company Z, you know, some Company Z out there has some patents in an area that you might want to enter or something. And, you know, what can you do about that? Maybe how do you get a license from them? And, you know, that's a defensive strategy. Well, you know, one way you might get licenses to have patents that they're interested in licensing back. And those are different kinds of strategies. And yeah, you know, there's other ones out there. You know, that's kind of some.
Yeah, I saw a great presentation. I was at a conference once, and a speaker said that, you know, the way you manage a portfolio depends on your patent story, right? And so then he gave some examples, and he put up on the screen, you know, like a Google type company that's filing lots of applications, and, you know, if you look at a cell phone, the number of patents that are required to cover a cell phone is enormous, right? So you have to file more applications, and so you have a different patent story and you have a different portfolio management approach, as opposed to pharmaceuticals where, you know, 1 or 2 patents can cover the whole product, right? So you don't file as many applications, but the applications that you file are more important potentially, right? And
oh yeah,
and we're certain businesses can rise and fall based on whether a patent grants or not, does not grant in the pharmaceutical area. So I think that, but then I think what's interesting about what you said too is that when you sit in your position and you're managing a portfolio which may or may not include, you know, a diverse set of technologies. You know, each application can kind of have its own story too, right? I mean, it's the business matters, but it also is like, okay, with this particular product, we might have a strategy that will cause us to make decisions that are different than another product, for example.
Oh yeah,
I would think.
Yeah, sure. Yeah. The strategy, yeah, well, it's going to depend on. I mean, it's going to depend on what are the business goals and what does the marketplace look like. I mean, I'm trying to think of like a good, you know, historical example. You know, if it's night, I'm trying to think of the exact dates to give a good example with, like, you know, the original landline telephones. You know, like if you start from a blank slate where there's no telephones at all, and you're the bell company, you know, you're going to have a different strategy than, you know, someone that enters the market in 1970, or it's just, there's, you know, multiple variables there, and it depends on, like, the, you know, even within a single market, what kind of products are you going to be fielding, or just like we keep going these different examples between, you know, tech and software versus pharmaceutical. You know, that seems like that's one of the. It's something you hear about repeatedly. There's different approaches there. I think those are two examples. I mean, when you look at anything, there's lots of nuance there on a strategy, because there's lots of different companies and lots of different businesses and different opportunities. And, you know, things become valuable and then they don't become valuable. And you know, there's different kinds of IP. You know, I was thinking about this. You know, there's some things where the IP, you know, the really valuable IP it might not be protectable by a patent, or, you know, even if it's it could be patentable, but the patent itself may not be useful. I mean, I think the textbook example there is something that is completely not, you know, the classic black box, whether it's a mechanical or a software invention. It's like, you know, if you can't figure out whether this claim, like, you know, you have a method claim for manufacturing something. It's like, if you can't figure out if someone's ever going to use it, then that's probably better for a trade secret. You know, whether that's the manufacturing method for a, you know, piece of semiconductor hardware, or, you know, going back to old cliches from patent and IP CLEs and seminars, you know, the secret formula for Coca-Cola. But there's, I guess, my point is, there's those examples are given, but there's a spectrum, and you really have to think about it. But if you stop and think about it, then you can manage different pieces of your portfolio differently. You know, you have an interesting product experience, and you have some cool stuff that's happening on the server side. Well, maybe it's protectable by a patent, or maybe you're better off not patenting that and keeping it as a trade secret. You know, the thing about that is, especially with the trade secret part, you better be right. You know, you don't get a second chance.
Yeah, exactly. You know, another example that comes to mind for me is I've worked with a medical device company in the Minneapolis area, and they made this comment to me that, okay, look, in our portfolio, we have, let's say, some catheter products and some stent products, and, you know, they sort of have all of these different things going on. They're not just a company that makes one device, right? And so they said to me that, hey, look, it costs us X amount of dollars to get a patent. That's the assumption that we make. And I said, you know, where analytics becomes interesting is that, in actuality, as I look at your portfolio, it costs you X to get a stent patent in this category. You know, it costs you Y to get a patent in this category, a stent patent in this category. You know, a catheter patent will cost you this. So once you sort of know, like, that the segments of the patent office where you're working are not all the same, you can sort of go shopping, right? It's like, look, when we really think of it that way, we would rather have, you know, 3 of these rather than 1 of these, right? We could get 3 of these in 6 years rather than 1 of those in you know, 8 years, right? You can sort of, all of a sudden it's a whole nother way to look at, you know, what your strategy should be, because the examiners are going to have a lot of impact on when you get your patent.
And then later
and how much it's going to cost.
Like the product life cycle. And then, I mean, and then what if you're, if you're so good at making sense that you're not, what are you going to do anything with those patents? Is it, I know that the medical device industry is another example of one of the different kind of flavors of industries out there, but you have to think about that. Like, you may have enough patents, if you have a portfolio and are covering, the newest parts of what you're working on, but like you were saying, the patents cost money, and you don't want to spend more on your patents than on R&D unless that's the business model. But again, it just comes back to being informed about what are the business's goals, and how, as inside or outside patent or IP counsel, how can you help advance those goals? I mean, sometimes the answer is by filing patents, and sometimes it's by not filing patents, or filing patents that sometimes it makes sense and others don't make sense. And it comes back to the analytics of it.
Yeah, suffice it to say that the image of in-house counsel with stacks of draft amendments sitting on their desk, and the job of in-house counsel being saying, looks good to me, looks good to me, looks good to me. That's what we say there is more than a rubber stamp. So if anything, with analytics, the opportunity to influence your portfolio and get a better outcome collectively is increasing. I'm going to jump to the next topic, which is working with outside counsel, because I think that this will be a popular topic. I think a lot of people especially will be interested in terms of understanding changes that have happened in terms of how you work with outside counsel.
Well, sure. Yeah, actually, rubber stamping being another good transition story. That's my note on that is you don't rubber stamp everything, and then also you better not be rubber stamping nothing. In the sense of if you should have a good relation. So my idea with working with outside counsel is you should have a working relationship and outside counsel who know enough about your goals to where you are rubber stamping some of it.
That's a great point. I think that's a great point, is that you have to spend the right amount of time on the right decisions, right? And that means that some decisions you shouldn't spend too much time on them.
Yeah, and I mean, I was thinking the 80-20 rule. I mean, I think a lot of in-house jobs have a wide variety of tasks and responsibilities beyond patent prosecution and management. And I mean, mine is one of those. I manage a portfolio, but I do other things. And so there's, you begin with a limit on your time anyway, but especially, even within the confines of work, there's a limited amount of time to work on the portfolio. So you want to spend it on the valuable stuff. And if you're doing the outside counsel's work for them, that's not good. That's not good for you or the outside counsel. And then if they're doing all of the work for you, that's probably good for them, but not good for you. So instead you need to understand what your goals are, and then you need to make sure that you're working with outside counsel that are kind of aligned with those goals, and everyone knows how to work with each other and how to advance those goals. One of the, I think, outside counsel guidelines and procedures. This is another one of my stories is always that I think everything I ever did wrong with outside counsel procedures has been revisited upon me. Like from improper use of IP management tools, emailing when I should have used a tool, or using a tool when I should have emailed, calling I called when I shouldn't have. I didn't call when I should have. All of these things have happened to me, I think, especially early on, and it comes down to communication and understanding of what the procedures are, and then also why are they there? One of my favorite ones was like I had back in private practice, I had lots of different clients. They all had different little procedures, and it was like, oh my gosh, why does this one want the file named like this, and why does this one want it named like that? And on this side of it, the file names are really important because sometimes, depending on how you work, you're looking at the file name. If you expect them to have a docket number in them, or you expect them to have like a little, maybe they say like non-final office action response, those little tiny optimizations seem unimportant, but they actually are you can get knocked out of your flow if you get to have a little bump. So, but yeah. I think guidelines and procedures also depends on the scale, right? I mean, if you have a small client or a solo client, obviously it's more of just hey, how do we work together best? What do you like? Should we email each other? Should we just do phone calls, periodic meetings? And on the in-house side too, that's also, it's like, hey, how does your business side client want to interact? What works for them? Like, how can you meaningfully convey information to them, and in a way that's both timely and also not taking away from their day job, if you're
exactly.
If you spend all your time,
the volumes have increased so much for so many companies. I mean, the amount of patents that people, if you look at one practitioner and what they're managing, it's pretty significant number. So, efficiencies, I think we're still evolving in terms of efficiencies. I don't know that anybody has found the perfect workflow and the perfect tools, and I think we'll see a lot of change, in the near future. So on our slide that we have here, we're talking about in our bullet point, just a couple of things that I think are maybe even a little more, I think they're current, but especially future looking. So it's really talking about, utilizing analytics for example, the assignment of cases to the attorneys that are the most effective with a group of examiners. I mean, it's an interesting idea, right? So we have conflict of interest that comes into play. So you can't really, if a firm is working for Microsoft in an art unit area, obviously they can't go and pitch to also work for Google and say, we're really great with these examiners. But, companies like Google have the opportunity now to say, are my attorneys, being as equally effective as my competitors' attorneys in that same art unit? Are the results the same, for example? So there's ways to benchmark now that never existed before to see, to evaluate performance, which is scary if you're a practitioner, I think.
Yeah, my thought on, how do you measure success? Evaluate. Well, I guess the way you phrase it, right? How do you evaluate outside counsel? That scares me. I still remember me from 6 years ago. That scares me.
Sure.
But then you're afraid. So turning around, like, how do you measure success? Hey, if you're, internally or externally, are you trying to improve your practice? Are you trying to maintain your practice? You can have your own personal goals, and if you think about evaluations as kind of a way of understanding how you're doing, I think it's still, like I said, there's still that existential scariness of confronting change in the world, and I don't want to minimize that. I mean, I think about it all the time, but but when you can acknowledge that, that's how you grow. That is how you get better, even when it stinks.
There's kind of two different kinds of things that we're talking about here. On the one hand, it's talking about, hey, now companies have the ability to live monitor whenever your law firm pays an extension of time fee, right? I mean, they can know the moment you file the office action, they can have a flag that pops up that says, hey, there was an extension here. And I will tell you that when I was practicing, and I'm probably going to have former clients send me emails now, but, you know, there was a time when I could file an extension of time and just kind of get away with it, right? Especially when a 1-month extension of time used to be almost nothing, right? And so you know, we weren't necessarily always being evaluated, you know, head-to-head in an extension of time contest, firm to firm, you know. But that's possible now, you know, and that's you know, it's a different world. But another category of analytics around performance is sort of, and let me tell you my theory. And my theory is that by far the majority of law firms are kind of all the same when it comes to performance within an art unit. And I think that that's true. My opinion is because the examiners kind of drive the show for the most part, right? So what we see in the analytics is that an examiner that averages, let's say, 2 office actions per grant has a very narrow, relatively narrow range about experiences that go outside of 2, right? So that's what it's really saying is that most law firms are going to land in the same spot. But what's really interesting to me is I think that companies going forward should really think about, hey, when you have a case that's with an examiner that doesn't grant very many patents each year, right, and is a more difficult examiner, to me what makes a good firm and a good attorney is the firm or the attorney that can identify as soon as possible during prosecution that they have difficult circumstances in that case, so that they can take action early in prosecution to try to change what would be the typical outcome for that examiner. So, for example, you know, most attorneys, if you have an easy examiner, an examiner that almost always grants with 1 office action, right, you know, almost any attorney can handle that case, right? But the case where the examiner that averages 4 office actions per grant, you know, if you can identify when you get your first final office action that you have that examiner and you can find a path that avoids that outcome, you know, I think more and more those kinds of evaluations and really getting into who is the best attorney strategically are going to become important. So I'm calling it for the future, but I could be wrong.
Yeah, I think it's an interesting possibility. I mean, one of the things I don't know if the data is out there yet, but I've actually kind of wondered. You know, I was at a couple different firms, and then I jumped in house. I do kind of wonder, like, you know, was I doing better? Was I doing better on average? Was I running about average? Was I worse than average? You know,
I can tell you if you want me to let you know, I can tell you.
Yeah, maybe offline, especially.
Yeah, exactly.
Yeah.
I did, you know, on our Better Patents Now podcast, we actually did an episode that was, would you hire Chris? And what we did is we went through my data, we looked at my data, and we actually, you know, made the call, would you hire this guy or not? And I have to tell you that I was maybe 50-50 on hiring myself.
Yeah. So you have to do
one thing
you have to have a few data sets there, and
yeah. Well, you can't look at allowance rate, for example, because, you know, I think that one of the big problems with the way analytics has sort of evolved, pre-grant analytics, is that we've become a little over-obsessed with allowance rate because, you know, by definition, so let me give you an example. So, you know, I had a large software client that abandoned a ton of applications in 2008 when things weren't going well, right? And so that's going to drive down my allowance rate. So and that's true of any practitioner. So analytics you have to be careful with them, of course, as we know. But so what I'm really trying to say is that once we start using analytics for, you know, choosing law firms and choosing practitioners, you have to be really careful. But I do think that there's an opportunity there in the long run, just as long as you do it carefully, right?
Yeah, I think the care is pretty important in my opinion. Like, I was thinking the example of the easy versus hard examiner, even like you know, there could be lots of things could be driving that, right? Like, you know, if you have an examiner that does 4 office actions, maybe they really have a picture of the exact words that they want to see in the claim, and maybe the whole time they think that they've had this idea of how this should be claimed, and that's what drove the 4 office actions. And maybe the 1 office action examiner was reading a lot into some of the terms in the claim, right? Like they read, you know, they gave some special meaning to a few of the elements that the other examiner would have, you know, required to be made super explicit. And so again, it's like,
right,
the analytics
right,
is
but
informative.
To your point, though, but think about it, you know, we are now, for the first time in history, we have the ability where if you have an examiner that averages 4, you can go out and look at the last 30 independent claims that they have allowed, independent claim 1s, for example, right? I can text search it. I can figure out why they are difficult, why they're long, and if I'm really a clever attorney, I could find a secret out of the collection of information that's available that would allow me to find a shortcut for you to get a better patent with fewer amendments. And so that's what I'm saying is that, you know, we are going to evolve as practitioners because the most clever prosecutors among us are going to be able to use the tools that are available to get better results, right? And then naturally, corporations are going to prefer those attorneys, right?
I mean, I think, I would, again, as my personal opinion, I think if someone is getting better results and you can prove it, of course, I think that's, you know, just like with, you know, if you can craft your language to be something, you know, you understand, hey, this is the examiner that wants it very specific, save yourself 3 office actions, you know, that's better for everybody, right? That's better for the client, that's better for the examiner. The examiner doesn't have to write 3 office actions if they,
yeah, what I've always said is that the law firm that can go to a company and make the case that they can acquire better patents sooner for less money is going to have an unlimited amount of work, right? If they can prove it and they can execute on that promise, then, you know, there's a real opportunity for that attorney or that law firm. And, you know, if you can use data efficiently, then, you know, there's a real opportunity. Well, I could talk about this stuff all day, and I hope that we get a chance to maybe do this again sometime. Maybe next time we can pull some statistics out of the system and put them on the screen and you know, have a good debate about what the numbers mean. That might be fun.
Yeah, maybe we can do my patent prosecution baseball card, see if I stay there for my rookie year. Up through
I would love to have you on the podcast sometime. And if you ever want to play, I'm going to invite anybody that would like to be on the podcast that would like to play the game, Would You Hire Me? You're more than welcome to play. But listen to my episode. Go ahead.
I was going to say, I think I've spent 45 minutes talking about how much I like goals and self-improvement. I'm still really going to have to think that one way over.
I think that's a good idea. The times have changed. Well, I think let's wrap it up for today. There's contact information on the screen if anybody would like to learn more about Patent Advisor Analytics. You can also feel free to contact Eric or myself if you have any follow-up questions. And I'll just make sure, I don't see that we have any questions from the audience. I don't think so. So why don't we wrap it up? I really enjoyed this. This has been great.
Yeah, awesome. Thanks again for having me, and thanks to everybody out there listening. I hope it was helpful and informative.
All right. Thanks, Eric. Have a great day.
Thanks. You too. Bye.